Good afternoon, everyone, and welcome to the second in our programme of webinars for the East Midlands Growth Hubs, all around preparing for EU exit. We're going to make a start. I recognise there's some people probably still going to join, but I think we'll make a start anyway because we've got quite a lot to cover in the hour that we have. So just to run through the agenda, so we're going to touch on a little bit about the EU Exit Support Programme, of which this webinar forms part. We're going to take a little bit of a look at the current situation with regard to trade between ourselves and the EU and what that starts to look like at the end of this year. We'll talk about Brexit and its impact, and then we'll move on to considerations and practical steps that you can take as exporters between now and the end of the year to best prepare so that your trade is as minimally disrupted as possible. And then there are a couple of slides at the back of the presentation that provide sources of additional information and support, which I'll touch on a couple of those points, but the slides are available to you as an attendee anyway, so don't feel like you need to scribbly write things down. So the EU Exit Support Programme, what does it contain? It's essentially, it would have been workshop support, but obviously with COVID restrictions, we've switched to virtual delivery. So we've got webinar support. And we've created 10 topical webinars, which give generic information that could be applied to all sectors, essentially, who are preparing for EU exit. However, for companies that have specific requirements or unique considerations, then we're also offering one-to-one support. And that's made up of an initial fact-finding session where we learn about your business, what preparations you've made already, and identify any vulnerabilities that remain. And then we go away and pull together a kind of targeted, dedicated action plan of activity that you need to be doing between now and the end of the year to make sure that you're optimally prepared. And we go over this action plan with you in a follow-up session just to make sure that you're totally comfortable with what we're suggesting you do. Now, all of these can be booked in the same way as you booked the webinar, so via the Eventbrite link. So you can book your one-to-ones. I think we have sessions available up until the end of November, so please feel free to go and book onto one of those. And then we've also provided the remaining programme of webinars that you're very welcome to join. So now and beyond the 31st of December, what does this look like? So if we look at our EU membership, so in addition to the 4 pillars of freedom that have really benefited our trade, our skills, our education, we've seen a number of other initiatives and directives that have served to better us as a nation. So things like the UK Human Rights Act, the EU Health and Safety Framework Directive, the Working Time Directive. We've also seen foreign direct investment into the UK effectively double since the creation of the single market, because we've effectively been considered as a gateway to Europe. We've seen lots of advancements in consumer rights and benefits, with the abolishment of data roaming charges, travelling rights in the event of delays or cancellations, consumer protection laws, and so on. And we've seen benefits to our national security also. So the membership of the EU has facilitated cross-country coordination and greater protection from terrorists, people traffickers, and cybercrime by such systems and arrangements as the Schengen Information System, Europol, and the European Common Arrest Warrant. But we voted to leave, and we've technically left on the 31st of January. So what does Brexit look like, and what's likely to transpire? So if you think about the current position, the withdrawal agreement was ratified on the 23rd of January, and it gained EU consent a couple of days later. So technically, we left the European Union on the 31st of January, but we've continued throughout the transition period to exist as one of the member states. Very, very little has changed. So EU laws continue to apply. In terms of our origin protocols, both UK and EU content continues to count towards those rules of origin in trade agreements. We've still had access to the single market and the customs union, and we've remained bound by obligations stemming from all of our international agreements, our EU international agreements. But we're no longer represented in the EU institutions, agencies and bodies, which, you know, has probably happened with very few people being aware of it, but we've no longer got representation in those bodies. The common external tariff continues to apply, although those of you importing and exporting will have visibility now of the new UK global tariff, which will replace the common external tariff for our imported goods as of the 1st of January. But in terms of frictionless trade, you know, we haven't had to make customs declarations with our EU neighbours. We still continue to be able to trade under the free trade agreements that the EU has negotiated over the years. And a lot of the laws governing export control and sanctions, embargoes and so on have continued to apply throughout this period. However, the 31st of December is kind of like the line marked in the sand. So the UK government declined to extend or apply to the EU to extend the transition period in June, July this year. So it means that we very definitely have an end of transition date of the 31st of December. And at that point, we become a third country in the eyes of the EU. So we no longer have access to the single market or the customs union. Any use of free trade agreements will no longer apply. Obviously, EU law ceases to apply, and a lot of this is, you know, formed the basis of the UK's decision to go for Brexit in the first place. But there are still a number of things that remain unsettled between the UK and the EU, even at this late date when we're really down to the wire, that cause UK businesses some concern, GDPR being one of them, although I don't want to go into too much detail about that today, it's for a separate session. But we're still down to the wire in terms of negotiations, and it's fair to say that there's still an awful lot of work to be done to ensure that there's minimal disruption as of the 1st of January. So I think it's important to understand where we're coming from and where we're going to. And this image illustrates the current EU trading landscape and the different levels of agreement the bloc has with countries and other trading blocs. So, like I say, as part of the transition period, we've retained access to these agreements. You know, so they're all colour coordinated here. So you've got customs union agreements where parties agree to eliminate customs duties in bilateral trade and establish a joint customs tariff for foreign importers. Then you've got association agreements, stabilisation agreements, free trade agreements where both sides remove or reduce customs tariffs in bilateral trade. And then you've also got partnership and cooperation agreements. But on the 1st of January 2021, the UK will no longer have access to what is over 77 countries with a variety of negotiated agreements facilitating that bilateral trade, nor will it have access to the further 24 in the process of being ratified or the 6 being negotiated. So it's important to understand where we're going from this vast landscape of free trade agreements and facilitation agreements to kind of starting from scratch in some cases. And the UK government's kind of been at a disadvantage in many respects because it was technically unable to negotiate new trade deals until the transition period kicked in. And even then, those agreements can't come into force until after the transition period. So the government is making headway, but it's an uphill task. So far, they've got 20 rollover deals or continuity agreements covering some 50 plus countries. However, I suppose the concern for some traders is the fact that these nations represent a small percentage of the UK global trade. So failure to strike a deal with the EU will see more than 90% of the UK's trade being done under the WTO terms and defaulting to most favoured nation tariffs. So there is a concern and there is enormous pressure on the government to try and strike something. I think Boris Johnson has drawn a line in the sand for this Thursday. I don't know whether that will be reached. But there are some real advantages to trying to strike that deal very, very soon to provide more clarity to traders. So looking at the impact, so while we effectively left the EU on the 31st of January like this year, as I said, our trade with the EU and beyond has been largely unaffected throughout the transition period. But as of the 1st of January, we, as I said, become a third country in the eyes of the EU, so the number of customs formalities increases, which means that businesses must present more documents and submit more information to customs authorities. If your company's been trading with markets outside of the EU, you'll likely be familiar with customs and clearance formalities. However, some companies, if you think about it, have never they've never had to face these. They've maybe only ever dispatched or acquired goods into free circulation within the EU, and so the change is considerable. And I think it's fair to say there's still a number of them unprepared. So when I'm talking about extra formalities and considerations, I'm talking about the fact that companies are going to have to understand what documentary requirements might apply to their products when exported to or imported from the EU countries. Similarly, they're going to have to understand the process at the UK and EU borders, and importantly, what kind of checks and inspections will be applicable to their goods. They'll need to check the origin of their products when exported to or imported from EU countries. So identifying the UK/EU/ non-EU content and whether they qualify as being of UK or EU origin. Now, the International Trade Centre's database of rules of origin provisions has details of over 350 trade agreements, including the EU's non-preferential rules of origin. So I've provided a link to that as part of the sources of information at the back. Origin is complicated. It really requires kind of like a bit of a deep dive. So if you are concerned about origin of your products and how that's impacted by Brexit, then I would suggest that we schedule a one-to-one and examine that in finer detail. If companies haven't started to already, they'll have to start approaching and discussing options with EU clients or suppliers, perhaps those that are particularly cost sensitive and could be disrupted by extra costs for import duties or customs clearance costs, higher freight costs, currency fluctuations, forgive me, I can't talk today, currency fluctuations, etc. They'll need to understand whether their goods are subject to any export or import licensing. And importantly, becoming familiar with the regulation governing their goods in EU markets will be absolutely paramount to understanding what documentation needs to accompany their goods and what kinds of physical or documentary examination might apply to their goods at both the UK and EU borders. And then I suppose really another consideration is around customs delays, and the ports have been working incredibly hard to prepare for this. But it's important that if you're working in a time-sensitive sector, that you consider how your EU clients may be impacted by potential customs delays and how you can jointly mitigate the risks associated with these. So considerations and practical steps. So there's a lot more clarification now than there was at the beginning part of this year, and we're starting to see the fruits of negotiation and labours that the government has been doing. So at the beginning part of this year, it was very difficult to understand the kind of border control considerations that were going to be in place for the EU and UK flow of goods. That's now in place, and we're going to look at the new border operating model. We're going to look at the Northern Ireland Protocol and how that impacts the flow of goods between GB and Northern Ireland. And then there's a number of other considerations that that we're going to look at as part of kind of preparing. And again, it is to a certain extent it's generic, and I'm not going to go into sector specifics, but the one-to-one sessions provide that opportunity for a deep dive. So moving on swiftly, so we've got the border operating model. So this was the 200 plus page document that the government published in July. And it essentially lays out an approach to implementing full border controls on the flow of EU-UK goods. So the document details a phased approach for imported goods, which has been obviously welcomed by the importing community. In some cases, it gives importers some 6 months to file declarations and pay duty and import VAT. So that's a huge coup for for cash flow and so on, which was a major concern going into this. This phasing said to be largely due to the impact of COVID on businesses and their level of preparedness, and essentially, it has detracted focus from preparing for leaving the EU. So this phasing approach really is welcome. However, contrary to imports, there's no phasing in of export procedures. Everything is coming into effect on the 1st of January, which means you have to get organised pretty quickly. This document, I think, provides much needed clarity, and it allows you as exporters to prepare for the changes ahead. So an immediate change, for example, will be that as a UK-based business sending goods from the UK to the EU, you'll have to complete a UK customs export declaration from January. And to do this, as a minimum, you'll need your GB EORI number. You'll need to be certain of the commodity code of your goods. And you'll need to have access to HMRC systems either directly, if you're going to be making these declarations yourself, or via an intermediary. And then lastly, you'll have to have a pretty good understanding of the trade tariff tool to determine what documentation and considerations you need to make for those shipments for your goods. So for example, where a license is needed to move the goods, or whether goods are covered by any additional duties or anything like that. Now, similar to imports, there exist a number of simplified procedures, for export. One of them is simplified declaration procedures. So they kind of enable faster clearance at the border by making or allowing you to make a simplified customs declaration or entry into your commercial records up front, and then following that up with a supplementary declaration up to 4 weeks later. If your goods are subject to safety and security declarations, your carrier will have the legal responsibility to ensure that UK customs receive pre-arrival or pre-departure information. So where you haven't yet made that export declaration pre-departure, a standalone exit summary declaration would absolutely be needed. Your freight forwarders, if you find a good one, they're worth their weight in gold, and they'll be on top of this, and they'll be notifying you of what's needed. I should say that there are a number of product categories that require additional controls, checks and documentation, and these are in the areas of things like animal origin, excise goods, etc. So if you think that your goods fall into one of these categories, these kind of controlled goods or special goods, it would be best to book a one-to-one so that we can explore your specific requirements in more detail, if that makes sense. And then really to cover the Northern Ireland Protocol, this is, or the Northern Irish Protocol, this is another area of clarity. So we can all hail back to 2019 when Northern Ireland became the focal point of the withdrawal agreement saga. And the result was effectively the production of the Northern Ireland Protocol. Despite many promises from government, many from the PM himself, this protocol serves to create a legal border down the Irish Sea. We understand that the overriding principle is to avoid a hard border on the island of Ireland and to provide that unfettered access to GB for Northern Ireland businesses. However, depending on where goods are moving to and from, they'll be treated slightly differently. So by that, I mean, for example, trade coming from Northern Ireland to GB, there'll be no additional processes, paperwork or restrictions. So that's great. That's a thumbs up, and the Northern Ireland Protocol achieves that objective. However, trade going to Northern Ireland from GB may face tariffs if the goods are ultimately entering Ireland rather than staying within Northern Ireland and the UK customs territory. There won't be tariffs levied on goods remaining within the UK customs territory, and that's important to stress. So it's only goods that will be eventually moved on to Southern Ireland or are at risk of entering the Southern Ireland market. There'll undoubtedly be additional processes on goods arriving in Northern Ireland, specifically, again, for those special goods, for goods of animal and plant health or agri-food goods that warrant specific checks and controls. And these will be implemented in border control posts within the Northern Irish ports. So Northern Irish ports at the moment are gearing up to be able to handle those customs formalities. And then VAT is another area, and this is a tricky area anyway, in a very specialist area, but essentially Northern Ireland remains aligned with the EU VAT and excise rules for goods, but will remain part of the UK's VAT and excise system. So it's a very, very murky area, and I don't suggest for a minute I'm going to provide much clarity around that today, but there are some very, very good VAT specialists out there that have a good handle on this, and anybody that has a specific query, I'm very happy to make a warm introduction. So essentially how it should work is that Northern Ireland goods entering GB won't face any customs checks or controls. However, goods leaving GB for Northern Ireland may be subject to declarations, checks, approvals, and maybe duties if the goods are destined for Southern Ireland. So if you're selling goods into both Northern and Southern Ireland, you need to understand what your obligations are and get your head around these pretty quickly. Moving on to the EORI numbers. So historically, if your business has been involved in import or export of commercial goods to countries outside of the EU, then you'll be really familiar with your EORI number, which is your Economic Operator Registration Identification number. We love our acronyms in international trade, so that's your EORI number. The EORI number essentially acts as a means of providing security and statistics in international trade. So it's used by customs authorities when exchanging information between themselves and with government departments. Last year, as we were peering over the side of a cliff and were looking at no deal in the eyes, UK firms were urged to apply for an EORI number as part of their no deal preparations and to secure ongoing trade, essentially. However, when uptake was relatively low, HMRC made the decision to issue all VAT registered businesses with one. So the result is that some organisations may now have two, which can lead to a level of confusion. But on the upside, at least they have a number. If you don't have one, which I'd be very surprised if you don't, but if you don't, it's simply a 12-digit number that starts with GB. And if you're VAT registered, it'll also include your VAT number. It's unique and it's an essential identifier that features on your export documentation. So it's a really, really important number to get right. And when you're sample checking your export documentation, that's one that you should always double check, because just transposing digits or leaving a digit out can result in delays and so on. If you don't have the EORI number, you can apply via the Gov website, and I provided a link in the later slides for that. The other thing to mention about EORI numbers is most EU-UK trade has been historically done door-to-door on what would be seen as an ex-works or the equivalent of deliver duty paid basis, which has been fine when goods are in free circulation and not subject to customs formalities or border checks. But if you continue to supply your goods to your customers' premises in the EU, depending on the Incoterm you use, you may be liable to make customs declarations to the local customs authority and maybe even pay import duty and VAT. In this case, you'll need an EU EORI number in addition to the UK one. So that's the circumstances under which you'd need more than just your UK EORI number. And again, quite happy to cover off some of these in one-to-one sessions. I wanted to touch on export documentation as well. So again, if you've exported directly or indirectly to a non-EU country or traded with one of the EU special territories, you'll be familiar with the C88 form, so affectionately known to us as the SAD document, standing for Single Administration Document. It's used for declaring imports and exports to HMRC. So there are 54 data boxes on the form in total, but required fields vary depending on the type of entry, so the type of goods and the customs procedure applied. If you've exclusively traded within the EU, you'll be new to this document, and either training or, again, the services of a really good customs intermediary will be required, as this will form your customs export entry for the shipment of goods to your EU customers. It's important to stress that a customs export entry, it's a legal requirement for all export shipments, and it must provide HMRC with full information about you, the exporter, and the shipment prior to the physical movement of goods. Now, entry errors happen, and quite often are very innocent, but they can lead to shipments being delayed, or more serious errors can lead to financial civil penalties. So I always stress the important roles of a customs intermediary and the role that they play. However, it's important to remember that the buck stops with you as the exporter, so the accuracy of customs export entry is your legal responsibility, and your agent will ultimately accept minimal liability for errors. So it's important to understand the fields that are required on your export declaration so that you can instruct your agent accordingly. It's also really important that you understand what other documentation needs to accompany your goods. So export licenses, certificates like country of origin or phytosanitary certificates, for example. All of these requirements will be listed against your commodity code in the UK trade tariff. And then, you know, if you're still uncertain, there's further clarification can be sought by your local chamber or local customs authorities in the country of destination. So if you can't find what you need, there are other sources of support that you can reach out to. Goods destined for the EU from the UK, we've historically referred to them as dispatches. However, as of the 1st of January, like I say, we become a third country and our dispatches become exports for real. And as such, we need to prove, as part of our compliance, we need to prove to HMRC that they've officially left UK shores, and as such can be zero rated for VAT. So this is what we refer to as our proof of export. So HMRC accepts several different sources of proof, but you must obtain this for every shipment and maintain it in your records for 6 years. And intermediaries don't always provide you with this proof as a matter of course. You may need to request it from them, but it's an essential part of your compliance with HMRC moving forward. Commodity codes, I find myself banging on about these a lot. You'll be very likely familiar with commodity codes, sometimes referred to HS codes or tariff codes. Currently, they're 10-digit long numbers for imports and 8 digits long for exports. They're standardized under the World Customs Organization harmonized system for the first 6 digits of the code, meaning that the first 6 digits of a product should be the same regardless of country. And the UK, after Brexit, will remain a participating country in this system. So the HS system allows additional digits to be set by customs authorities. So numbers 7 and 8 are currently set by the EU as part of the Common External Tariff, and then figures 9 and 10 are set by the UK itself. Tariff, they can sometimes extend beyond 10 digits, but it's usually only in the case of cap goods. The point I'm trying to make and why I've raised commodity codes is it's essential that you familiarise yourself with your codes and check them against the UK trade tariff. It's fair to say that in addition to us scrutinising goods coming in from the EU with our new border control mechanisms, our goods will be subject to increased scrutiny and checks at the other end. And so the correct classification of your goods, as I say, is again part of your legal responsibility, and everything hangs off your commodity codes. So that's why they're so important. You know, they're required for all customs declarations. They dictate internal taxes and duties. So in the case of export, they dictate what duties and taxes your customers will be paying on your goods. They dictate whether a proof of origin is required. They feed into trade statistics. They determine whether the goods need any certification or licenses. And they provide details of any sanctions or embargoes or restrictions. So they're a really, really important code to get right. And again, when you're sample checking some of your declarations, that's one to absolutely focus on, because similar to your IORI number, transposing a digit or leaving a digit off is can equate to a whole world of pain. There are a number of ways to keep abreast of changes to the tariffs. So the tariffs and organic tools, so new commodity codes appear all the time. You can subscribe to HMRC's updates, which I've provided a link in the support pages. You can also consult HMRC if in doubt, so you can email the Tariff Classification Service. Again, I've provided a link, and they'll give you a non-legally binding advice on classifying goods. And then if you want that further belts and braces approach, you've got the option of applying for a binding tariff information, whereby you submit data and perhaps samples to HMRC, and they will give you a tariff code that's legally binding for 3 years. So lots of ways to provide security and clarity around commodity codes, but you must check them as they dictate. But basically everything hangs off them, to be honest. I wanted to touch on export pricing as well. So if the UK and the EU fail to strike a deal imminently, then our goods will obviously be subject to most favoured nation tariffs when entering those local markets. And this is a source of concern for you as exporters, I suppose, when considering your competitiveness in the local market, especially if you're faced with stiff competition from other local competitors, or perhaps other international competitors that are able to still continue trading under preference or under a trade deal. Now, I understand that, you know, competitiveness isn't all about cost, but on the cost side of things, it is possible to gauge how your export pricing may be impacted in the case of a no deal. So there are a couple of sources to help you identify duty and taxes that will be applied to your goods. Historically, I've always consulted the EU Market Access Database. However, the government's also launched the Where Would You Like to Export To, which is kind of a database that provides this insight as well. So both of them provide the insight, and I've provided the links in the support pages, but they provide the insight into the local market duties and taxes that will impact your competitiveness in the absence of a no deal. I suppose this doesn't really make up for the fact that, you know, we become slightly more difficult to trade with customs formalities and so on. So that may perhaps impact our competitiveness also, but at least we've got visibility over what our export pricing may look like moving forward. I wanted to touch on country of origin as well. Again, if you're a manufacturer on this webinar, you're likely already familiar with rules of origin and proof of origin. Essentially, the rules of origin are the criteria needed to determine kind of the national source of a product. So they're the rules that determine, you know, the country of origin. And since that source can dictate duties and restrictions in international trade, determining that origin is really important. Now, why do I raise it now? Well, once out of the customs union and in the absence of a trade deal, it's highly likely that you'll need to declare the origin of your goods when exporting to the EU. And this gets particularly complicated if your components are manufactured in more than one country. So if you think about it, origin protocols are essentially concerned with identifying whether a product's either been wholly obtained, and by that, you know, the example I always use is kind of cattle reared in one country or grain grown and harvested in one country, so that would be wholly obtained, or alternatively whether they've been sufficiently transformed. So that's where you're looking at the source materials and the amount of processing performed, and depending on that, you know, whether that country where the processing has taken place is able to claim origin. Now, up to now, both UK and EU content is counted towards the rules of origin requirements in EU trade agreements, which is great, but this will cease as of the 1st of January, and EU components will be classified as non-originating. So companies may have increased difficulty proving that goods have been sufficiently transformed to be of UK origin. Now, it's a complex issue and it's subject to many tests and calculations. And of course, we don't know which rules of origin classification will apply to trade between the UK and the EU. But this time could be really wisely spent trying to understand the makeup of your goods if you don't know that already, and whether or not they're likely to be deemed as being of UK origin or not. Now, I've provided a link to the WTO Rules of Origin guidance on the support slides. And then, you know, specific queries or calculations we could cover off in a one-to-one session if you think that origin is a major factor for you. I wanted to cover export licenses as well. So the export strategic goods and technology is the remit of the Export Control Joint Unit, which if you're involved in export licenses, you'll know this already. Certain goods fall under their remit and are subject to controls. So this could be for a number of reasons. There could be concerns about repression or regional instability or other human rights violations within the market that you're exporting to. Or there could be concerns about the development of weapons of mass destruction. Or the target market could be the subject of EU or United Nations trade sanctions or arms embargoes. So again, your commodity code plays a very, very important part here, because that will dictate whether or not you need an export license for your goods. There are some changes afoot with export licenses and Brexit. So currently, as you would expect, all military goods, regardless of destination, require an export license. However, historically, UK exports of dual-use goods have only required a license if the destination country is outside of the EU. And how this changes is, after the transition period, the export of dual-use goods from the UK to the EU will require a license. So if you're exporting dual-use goods to any of the 27 member states, you will require a license as of the 1st of January. And I think it's important to members to mention as well is that export licenses issued by the UK as an EU member state will no longer be valid for exports to the EU 27. So again, a bit of a complex area. I would strongly recommend that you consult the ECJU if you think you have an export licensing requirement. Happy to support you also, as will be the local chambers and so on. But the ECJU are the the area that can provide that ultimate clarification. I wanted to touch on regulatory compliance as well. So if you think about the EU and the UK, we're so tightly integrated. So much regulation and legislation has been passed over these last 40 plus years. And, you know, detangling ourselves from that is a complex task and could never be completed in the time that we gave ourselves effectively. So there are a raft of regulations and directives that may apply to your products and may impact your ability to trade if the UK and EU don't strike a deal. And it's something that has been in my mind from the very beginning, really, when we've been asked over the years, what do we think will pose the greatest challenge for UK businesses in the case of a no deal? And a lot of people have talked about tariffs, but you know, I'm a firm believer that it's the regulatory impact that will be most damaging. And I think it's important to stress that no matter where negotiations are today, there's already regulatory changes that are afoot that are impacting businesses. So a couple that I mentioned here are REACH, which impacts a number of our clients. That's the EU's registration platform for chemicals coming into the EU. So manufacturers and importers have a duty to register products on this system. But from the 1st of January, GB-based companies currently registered with the EU REACH will no longer be able to sell into the EEA market without transferring their registrations to an organisation based in the bloc. Now, I make the distinction between UK and GB because under the Northern Ireland Protocol, the process for businesses in Northern Ireland moving goods to and from the European Union under EU REACH won't change from January the 1st. So essentially, GB businesses now have to register on the UK REACH platform and then take other action to continue accessing the EU markets as well. So it's just a layer of complexity that perhaps wasn't there before. Another one that we've come across as clients is placing manufactured goods on the EU market. So there are now 3 sets of guidance replacing what was one clear directive, depending on whether you're placing goods on the market in GB or in Northern Ireland from GB or in Northern Ireland from the EU. So just another layer of complexity that companies don't need. Another one that you're probably aware of is the CE mark. which is the European certification mark that indicates conformity with health, safety and environmental protection standards for those products sold in the EEA. And Brexit has implications over where and how this can be applied in the future. So the UK has developed its own mark, the UKCA mark, which stands for UK Conformity Assessed. And that's the new UK product marketing that'll be used for certain products placed on the UK market moving forward. However, as you would expect, the UK CA mark won't be recognised on the EU market. So products that require CE marking will still need a CE mark to be sold in the EU. The implications of this are essentially where a UK-based notified body has assigned your CE mark, it won't be valid, and you'll have to work with a notified body, a notified registered body in one of the EU 27 member states. So our kind of accreditation bodies and so on cease to be recognised. Now, I believe that BSI is actually an EU 27 notified body because it has a base in the Netherlands for certain regulations and directives. So it could actually grant both UKCA and CE marks. So take a look at their website for further details if you're impacted by this. Again, a lot to take in. You know, I would say sanity check your regulatory requirements for your goods and obtain the latest data concerning negotiations and carryover agreements. And gov.uk is a great source, as are your federations and associations who've probably been, as in the chemical sector, been lobbying government for some time for further clarity. So your trade associations and federations and gov.uk are great sources of information here. I'm going to touch very, very briefly on intellectual property rights. So if we, and I'm not an IP specialist by any stretch of the imagination, but we're led to believe that in terms of intellectual property rights, experts say that the UK's intellectual property laws and the extent of protection provided to rights owners will remain largely the same. And this is because most IP rights covering the UK are national rights anyway. Similarly, EU intellectual property laws have already been largely adopted into UK law, or at least will be retained moving forward. But I suppose there's still a couple of salient points to make, which are, firstly, I suppose registered EU trademarks and community registered designs will no longer cover the UK. But on the flip side of this, the UK will automatically create new comparable UK trademarks and registered designs, so you're kind of covered from that perspective. The other one would be owners of pending EU trademark applications that haven't proceeded to registration by the end of this year will have 9 months to apply for comparable UK trademarks. So there's a bit of breathing space there. There may be some loss of future IP protection caused by the UK and EU ceasing to provide kind of reciprocal protection, although this may yet be ironed out in any subsequent trade deal. And then I suppose, as is the case with regulation, there is, you know, the risk that over time there'll be some divergence. So in much the same case as regulation, we may see areas in which the EU and UK IP laws start to diverge in the longer term. So I suppose the takeaway from this is use this time to take a good look at your IP protection and whether it's sufficient moving forward. And again, I'm not a specialist, so I would say absolutely seek advice from either the Intellectual Property Office or a specialist in IP law. And then I wanted to touch on customer and supplier contracts. So some of the terms in your existing contracts with partners or customers or suppliers may no longer be relevant after the end of this year and may raise legal or practical questions in the future. So take this time to scrutinise your contracts. Check whether they refer to any terms that should be reviewed in light of the UK leaving the EU. Check to see if they make any references to the UK being a member state. and whether they rely on any EU regulation being applicable to the contractual arrangements. So take some time to take a look at those contracts, and you'll probably find that your EU counterparts are doing the same or may have already done the same. And then I wanted to touch on delivery terms negotiated with customers and suppliers. So as I said earlier, most EU trade has tended to fall into two kind of door-to-door categories: ex works, or the equivalent of what will be deliver duty paid, or DDP. And these terms were absolutely fine when customs processes were not required. However, Brexit brings a lot of complications. So deliver duty paid, or DDP, places the maximum obligation on you, the seller or the exporter, in exactly the same way as ex works places maximum burden on the buyer or on your customer. So if your current mode of delivery equates to what will be DDP, after the end of this year, then you'll be taking responsibility for import clearance and perhaps, well, absolutely with DDP, payment of taxes and or import duty in that local market. So you might want to reconsider and renegotiate your terms. Local market customs can be highly problematic for an exporter. They can be complex and bureaucratic. So where possible, it's best left to your customer and their agent that has that local knowledge. And I would be very surprised on the flip side that if you are supplying any of your customers ex works, that they haven't already reached out to you to look to renegotiate that as well, because ex works would place you know, the same kind of burden on them. They'd be responsible for making export declarations and then getting the goods to the local market. So they don't want to be involved in that side of things any more than you want to be involved in the local customs side of things. So it's a time to review those contracts and reach out to suppliers, contracts, customers, partners, to see if there's any flexibility moving forward that makes both of your lives that little bit more easy moving forward. So that's kind of a whistle-stop tour of things that you should be looking at. Again, the one-to-one sessions provide a much deeper dive into areas of consideration that are specific to your business and the products and your you know, the current way that you ship those products. But I did want to provide some sources of information for you. So things that we've already covered, so how to apply for your EORI number. The new border operating model is a published document, so that's available for you all. It's great bedtime reading at 206 pages, but it does lay out very clearly what your obligations are as an exporter. I wanted to touch on simplified procedures for import and export. I've given a link there because there's something that you might want to look at to kind of reduce the administrative burden placed upon you from the 1st of January. I wanted to touch upon training as well. So even if you employ the services of a freight forwarder or agent, because the buck stops with you, because it's incumbent on you to be making sure that you're compliant, understanding your obligations and understanding the information that freight forwarders need is really, really, really important right now. So there are several different training providers out there. There's the Institute of Export, but also your local chambers have a number of really, really good training sessions on as well, and the link to the chambers is provided on a separate page. There's grant funding available. So HMRC grant funding will fund training, recruitment and IT requirements as a result of having to process more documentation. So I've given the link to those grants. Again, finding a good freight forwarder, if you're not already using one, they really can be worth their weight in gold. So consulting the BIFA website can give you a starting point in terms of who you should be using. Classifying goods, so you remember me talking about the commodity codes. So I've given you a link to the UK trade tariff, so you can start familiarising yourself with that, maybe check your commodity codes. If you're in any doubt, I'm quite happy to look at those for you, but again, HMRC has a very established mode of operating whereby they can help you with those, and I've given you those links to those emails there. you remember the two systems that I talked about that can help you determine what your export pricing is. So I've provided the links there. Again, I've always used the market access database, but the system that the government's just launched, I believe, is quite good as well. What else? Going down here. A lot of this we've covered. And then in terms of sources of additional support, so you've got the growth hubs, which are probably the route that you found this webinar in the first place. You're free to contact them. You've got the export department that's delivering the session today, so you're very free to get in touch with us. BEIS has just started some really quite good 45-minute webinars entitled Check, Change, Go. It's worthwhile signing up for those. They're sector specific, and it might just cover some stuff that you're not aware of. Department for International Trade, fantastic resource again. Feel free to tap into any of that. And your local chambers, if you're not connected with them already, you probably should be. So you can find your local chambers via this route. And then in terms of wider kind of webinar programs, the Institute of Export has the Open to Export program, which has a whole raft of pre-recorded webinars on a whole range of subjects, a lot of which are EU exit support related. So they are also a very good source of information. And then really, that's it. If you haven't already signed up for the rest of the webinars, then please do so for the ones that are applicable to you. If you feel like you would benefit from some one-to-one support to discuss your business, you know, particularly your specific requirements and circumstances, then I'd be delighted to support you with that, have some time with you and provide a kind of dedicated action plan to help you prepare. So there are my contact details, and you have the link. I will send out the presentation so that you have the slides and that you have the relevant detail on there for support information and so on. But I'm just going to check if we have any questions before we close off. Oh, that's a very good one, Tom. Do we expect to hear about deal, no deal this week or at the end of the month? It's a very good question. I think Boris Johnson has drawn a line in the sand for this week, effectively, and we're led to understand that fisheries are the main sticking point. So we determined from that that the state aid issues have kind of been resolved. We're already beyond where the deadline was originally set, because ratification of any deal from the UK side of things is really straightforward, but ratification on the side of the EU is complicated because they've got to get 27 member states to sign off on something. So I would say we are in, if we're still at the end of this month without any headway, then that's not a good place to be, which is probably why Boris Johnson's starting to, you know, pin them down to a date, which I think I heard on the news last night was Thursday this week. So I'm sorry, I can't be any more specific about that. Any further questions before? Oh, you're welcome, Tom. Any further questions before we leave it there? Please feel free to get in touch with anything specific to your circumstances. But failing that, thank you ever so much for your time today. It's been great presenting. Oh, hold on. Shall I move my business to Northern Ireland? In terms of kind of specifics around that and the legal and tax implications and so on, it might be better covering offline because it's quite a complicated subject. If you'd like to follow up with an email with your contact details, then I'm quite happy to have a dialogue with you and kind of explain what the options are there and what the ramifications of those are. But it's certainly something that, you know, people are thinking of. Some people have already acted on it, maybe not Northern Ireland, but certainly we've seen some companies move their trading locations to Southern Ireland. So I hope that's answered everybody's questions and you found it useful. And And yeah, I look forward to catching up with you either on the next webinar or maybe on a one-to-one very soon. Thanks ever so much, everyone.